So here's a question that makes everyone uncomfortable. What happens to all your stuff when you die if you don't have a will or an estate plan in place? Your house, your bank accounts, that collection of vintage sneakers you spent 10 years building, even your social media accounts. Does it all go to your spouse, your kids, the government? Here's the thing that's going to surprise you. The answer depends on where you live, who your family is, and some laws that were literally written decades ago. I'm going to show you exactly what happens when someone dies without a will. It's way more complicated than you think, and the one scenario that could leave your loved ones completely broke even though you had money in the bank. Let's dive in. Hey everyone, welcome back to the channel. If you're new here, I break down complex legal and financial topics into stuff that actually makes sense. Today, we're talking about intestacy, which is just the legal term for dying without a will or a plan in place. And before you click away, thinking this doesn't apply to you, consider this. According to recent surveys, nearly 67%, two-thirds of Americans don't have a plan. That's two-thirds of people. That means most of us are planning to let the state decide what happens to everything we've worked for. So whether you're 25 or 65, this affects you. Okay, first things first. When you die without a will, your state goes through something called intestate succession. Think of it like this. The state has a default will already written for you, whether you like it or not. Each state has its own intestacy laws that determine who gets what. And these laws follow a pretty strict hierarchy, kind of like a family tree that the government drew up without you. The probate process. Here's what exactly happens step by step. Step 1. Someone has to petition the court to open probate. Usually it's a family member. Step 2. The court appoints an administrator, basically someone to manage your estate. This is like an executor, but court appointed instead of chosen by you. Step 3. The administrator identifies all of your assets, pays all of your debts and taxes, then distributes what's left according to state law. And here's the kicker. This process can take anywhere from 6 months to 2 years. During that time, your family can't access most of your assets. Your bank accounts get frozen, your house sits empty, everything is in legal limbo. The hierarchy of heirs? Now, let's talk about who actually gets your stuff. This is where it gets interesting. Every state follows a priority system, but they're not all the same. Generally, it looks something like this. Tier 1, spouse and children. Tier 2, parents. Tier 3, siblings. Tier 4, grandparents. Tier 5, aunts and uncles. Tier 6, more distant relatives. Sounds simple, right? If only you knew. The spouse situation. Does your spouse get everything? Here's what most people assume. If I die, my husband gets everything, or my wife gets it all. Nope, not usually. In most states, including Georgia, if you die with a spouse and children, your spouse does not get your entire estate. Let me give you a real example. Let's say you live in California, a community property state. You die with $500,000 in assets, a spouse, and 2 kids from your current marriage. Your spouse gets 100% of the community property, but here's where it gets weird. Any separate property you owned gets split. Your spouse might get 1/3 to 1/2, and your kids split the rest. Now, let's change the scenario. Same situation, but one of your kids is from a previous marriage. In many states, your spouse's share just got smaller. Why? Because the law wants to protect children from previous relationships who might otherwise get cut out. The community property versus separate property split. There are 9 community property states, which are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. In these states, most property acquired during marriage is considered jointly owned. When you die, your spouse already owns half, and the other half gets divided by intestacy laws. The other 41 states, Georgia included, uses separate property rules. Here, ownership depends on whose name is on the title. This can lead to some wild outcomes. Picture this. You bought a house before you got married. It's in your name only. You die without a will. In some states, your spouse might only get a third of that house, with the rest going to your parents or siblings. Your spouse of 20 years could end up co-owning the family home with your brother. Awkward? Doesn't even begin to cover it. Although I practice here in Georgia, a separate property state, I will ask clients which states they lived in sometimes to determine ownership of assets. When kids are involved, if you have children and no spouse, this one's more straightforward. Your kids split everything equally. But here's where it gets complicated. Scenario 1, minor children. If your kids are under 18, the court appoints a guardian to manage their inheritance until they reach legal age. And guess what? You don't get to choose who that guardian is. The court decides. And here's the part that shocks people. In most states, when your kids turn 18, they get the full amount, all at once. Imagine your 18-year-old inheriting $400,000 with no guidance, no gradual distribution, no restrictions, just a teenager with more money than they've ever seen. Scenario 2, estranged children. Here's another uncomfortable truth. Intestacy laws don't care about your relationship with your kids. That child you haven't spoken to in 15 years, they get an equal share with the kids who took care of you. That's because intestacy laws are about biology and legal relationships, not emotional bonds. Scenario 3, stepchildren. And here's the heartbreaker. Stepchildren you raised since they were toddlers, if you never legally adopted them, they get nothing, zero. Intestacy laws only recognize biological children and legally adopted children. That's it. When there's no spouse or kids. The extended family deep dive. Okay, now let's say you die without a spouse or any children. Who gets your stuff then? It goes to your parents. If both parents are deceased, it goes to your siblings. If you have no siblings, it goes to your grandparents, then aunts and uncles, then cousins. The state will literally search your family tree to find someone, anyone related to you. The laughing heir problem? There's actually a legal term called the laughing heir. This is a distant relative who inherits from someone they barely knew or never met. Imagine your second cousin twice removed, someone who you've never spoken to, inheriting your entire estate just because they happen to be your closest living relative. They'll be laughing all the way to the bank. Some states have laws to prevent this, cutting off inheritance rights after a certain degree of relation. Others, like Georgia, don't. When there's literally no one, it escheats to the state. Here's the ultimate outcome if the state can't find any relatives. Your property escheats to this state. That's the legal term for it. Everything you worked for your entire life goes to the government. Your house, your savings, your business, all of it becomes state property. This is rare, but it happens more than you'd think, especially with people who were estranged from their family or outlived everyone. Special situations. Unmarried partners. The worst case scenario. Here's the scenario that's becoming more and more common. You've been with your partner for 15 years. You live together, share everything, build a life together. But you're not married. You die without a will. Your partner gets nothing. Absolutely nothing. It doesn't matter that you've been together longer than most marriages. It doesn't matter that they can prove you wanted them to inherit Intestacy laws don't recognize domestic partnerships in most states. Georgia only recognizes them if the couples met the requirements before 1997. Your parents who you haven't seen in a decade would get everything. Your partner could literally be evicted from the home you share. Digital assets, the new frontier. Here's something most people don't think about. What about your digital life? Your email, your social media, your cryptocurrency, your online businesses, your cloud storage with 10,000 photos. Without a will, your family may not be able to access any of it. Tech companies have policies that sometimes prohibit account access, even by your next of kin. I've heard stories of families unable to access a deceased person's phone because they didn't know the password, and Apple refused to help without a court order. Business ownership, a potential disaster. If you own a business, dying without a will can destroy it. Your business ownership gets divided according to intestacy laws. Multiple family members might suddenly own equal shares of your business. Imagine your spouse, your 3 children, and your mother all becoming equal partners in your restaurant. Nobody has authority to make decisions. Everyone has competing interests. The business often has to be sold just to divide the assets, even if everyone wanted to keep it running. The real cost. Financial impact. Let me break down what intestacy actually costs your family. Time. Intestate estates take 50% longer to settle than estates with a will or trust. We're talking years of legal limbo. Money. Legal fees, court costs, and administrative fees eat up a significant portion of the estate. Estimates range from 3 to 7% of the total estate value, sometimes more. Taxes. Without proper planning, intestate estates often pay more in estate and inheritance taxes. Family conflict. This is the big one. When there's no will or trust, family members fight over who gets what. Siblings stop speaking, families fall apart. Studies show that family disputes are 3 to 4 times more likely when someone dies intestate. Emotional toll. Beyond the money, think about the emotional impact. Your family is grieving, and instead of focusing on healing, they're stuck in court, filling out forms, arguing with relatives, and waiting for a judge to decide what happens to your stuff. They're dealing with your loss and a legal nightmare simultaneously. So here's what we've learned. Dying without a will or plan means the state decides who gets your assets, not you. Your spouse might not get everything. Your kids could inherit everything at 18. Your family faces years of legal hassle and thousands in fees. People you don't want to inherit might get everything. Here's the thing that frustrates me most. All of this is completely avoidable. I know thinking about death is uncomfortable, but not having a will doesn't protect you from dying. It just makes everything harder for the people you love. So here's what I want you to do. If you don't have a will or a plan, put a reminder in your phone right now to create one this month. If you found this helpful, hit that button and subscribe for more content about protecting yourself and your family financially. And drop a comment below. Do you have a will? If not, what's holding you back? Thanks for watching, and I'll see you on the next one.